Yes, well, let's begin, shall we? As some of you may know, my name is James Morton, and I do have the pleasure of being co-chair to the Civil Litigation Forum, as is dreadfully common on the second day of any two-day program. People do sort of dribble in first in the morning, but as we do have a very full day, I think it's prudent that we begin now. I understand most of the speakers will probably be at the lectern, if that helps with the televisions. It's funny, I remember when I first came to Osgood, there were no televisions, and they had these huge things, and now they've got something that looks like it could fit in your coat pocket. In any event, that's completely irrelevant. Professor Walker is our next speaker, and she will be speaking about the challenges of multi-jurisdictional litigation. Her paper, which I believe everyone has, if you do not have it, it is available at the front, so please pick up a copy, which would be very helpful. Professor Walker is on the faculty of the Osgood Hall Law School of York University, where she teaches conflicts of law, international business transactions, and civil procedure for the LLB program, and transnational litigation in the LLM program. She has written extensively, and I'm looking at her resume, which is very long and very impressive. Just a number of things in it. She's the international advisor to the American Law Institute on Transnational Rules of Civil Procedure project, and this past autumn she gave lectures in China on the integration of the legal systems of China. I would ask you all to welcome Professor Walker for a topic which I've had some dealings with over the years, and I've never quite got straight. So, Professor Walker.
I'm sure you are far too modest on that last point. First of all, can everyone hear me? I know I have a very bad voice. I sometimes say to myself, if I'd had a better voice, then maybe I'd have been brave enough to try to do litigation rather than just teach it. So I'm particularly honored to have you here today, all of you who do litigation, and have braved the traffic that almost got the better of me to come and hear this talk. And thank you very much to the organizers of the Civil Litigation Forum for inviting me to be here. Today I've been asked to speak about contests between jurisdictions in a global economy. And that seemed to me entirely apt, because here we are at the turn of the century, and I would suggest at the dawn of a global economy. Now, of course, many of you will say global economy, well, that's very 20th century. We have multinationals driving our economies throughout the world, and we speak about globalization and the problems it is creating for us, and challenges it is creating for us, so much so that surely this is old news. And I beg to differ with that, and that's sort of the starting point for my talk today, because I would suggest that the horizontal integration, if you will, of the global economy through the multinationals and that thin sector of sophisticated large businesses is really only the beginning of the global economy, and the real integrated global economy must be vertically integrated. That is, one that takes into account also individuals and small businesses who would ultimately regularly do business across borders and thereby enter into the global economy. I think that is still, in many ways, very much ahead of us. A global economy is no more comprised of just the large multinationals than the legal profession is comprised of only the half dozen or so largest firms in any major business center. Now, the global economy is going to be very important for us, because as it becomes vertically integrated, so too will the need for our services become spread throughout the profession. And this is where I pause to say, no, this is not my usual advertisement for conflicts of laws courses. I'm very much in favor of those courses, not only because I teach them, but because I think they bring a better understanding throughout the profession. But no, that's not what this is about. This is about the fact that the vertical integration of the global economy, I think, will change the nature of contests between jurisdictions. And so I hope you'll indulge with me for the next few minutes at least, or 20 minutes or so, in some speculation about how it will change those contests of jurisdiction when we have not just large, sophisticated businesses involved, but individuals and particularly small businesses involved in these contests between jurisdictions. The first two kinds of contests I'm going to talk about are ones that we have certain familiarity with, the first being one that involves jurisdiction agreements. Contests between jurisdictions involving jurisdiction agreements have been around with us for some time now, and I would suggest that the solutions that we continue to devise for them now are really still solutions suited for that horizontally integrated global economy and not for one that involves also individuals and small businesses. Now, where would we find sort of the current consensus, the state-of-the-art statement about how jurisdiction agreements should impact upon contests between jurisdictions? I would suggest that area of the law can be found in two places. One of them is in the Hague Convention, the Draft Judgments Convention, which will hopefully eventually result in a worldwide agreement or a multilateral agreement that covers many of the countries in the world to agree upon certain bases of jurisdiction which they will allow their courts to exercise, and thereby create a comfort level so that other courts throughout the world will be happy to enforce their judgments. So it is very much a multilateral consensus-building effort, and it is one that is addressed, among other issues of how to treat jurisdiction agreements in resolving contests of jurisdiction. The other place that I would suggest that we could look is in the work of the International Law Association, in particular its Committee on International Civil and Commercial Litigation. The International Law Association has been around for about almost 140 years, and they meet every 2 years at conferences throughout the world. There is some hope that in 2006 we will have them here in Toronto. And in between times, the committees of the International Law Association, which have many, and I'm not simply being flattering, but many very highly respected experts in various fields such as arbitration, trade law, feminism in the law, civil litigation, meet and try to establish some consensus about where the law is and where it should be headed. So the International Law Association Committee on Civil Litigation and Civil and Commercial Litigation presented its report in July this year in London at the conference, and its suggestions were remarkably similar to those of the Draft Hague Judgments Convention relating to how jurisdiction agreements should be treated. The International Law Association noted that there was a difference in the treatment historically between the civil law and the common law. In the civil law, jurisdiction agreements tended to be followed. The courts, if they were given jurisdiction in the agreement, would assume it, and if they were not given jurisdiction in the agreement, would assume that they did not have jurisdiction and should decline. In the common law, however, jurisdiction agreements have been treated with a certain hostility. Traditionally, they were seen as some sort of private and suspect agreement to oust the authority of a public body, and so they were treated with a certain skepticism. An objection to a jurisdiction agreement would effectively, I suggest, toss it almost out of the window, or at least put it on the sidelines, so that the court could then look at traditional factors relating to convenient forum, where the witnesses and evidence was, where the parties resided, where the events occurred, which was the applicable law, and all those sorts of traditional factors that operate without an agreement. And then it would compare the effect of the jurisdiction agreement against those and see whether to uphold the agreement. I think this is basically a rejection of contract law principles, and I think that this is the way they traditionally operated. The ILA Committee and the Draft Judgments Convention propose effectively that jurisdiction agreements should be followed. And that is kind of the net effect of what their proposals are, that we should move away from this sort of ongoing hostility towards them and simply follow them. I think that this is a wonderful solution for large, sophisticated parties who have negotiated their contracts, eyes open and fully aware of the consequences. And in that respect, it is quite a sensible arrangement for them. But I think as we move forward into a vertically integrated economy, we will see courts continuing to refuse to give effect to jurisdiction agreements, and under such circumstances where we think that this might be appropriate. The question is, if we are at the juncture right now where we agree that they should be given effect to, except where there is some strong cause, and that is the term that's generally used now, not to give effect to them, what should be the basis of our analysis for that strong cause? If you look at the cases today, you'll find that they give lip service to this strong cause idea, but when they go back to review the agreement and the circumstances and decide whether or not to give effect to it, effectively they return to the old approach of looking at forum non-conveniens principles that would operate even if there was no agreement. And I think that this is an inappropriate approach to take. Really what courts should be doing is not looking at jurisdiction agreements in the context of the law of jurisdiction. They should be looking at them in terms of the law of contract. So in other words, they should be analyzing the nature of the bargain, whether the parties were capable of understanding the bargain that they'd reached, whether they were ad idem on whether there was consideration. And I guess, they could take into account major inconvenience in the way that you would force majeure, or the way in which you would suggesting that the contract is unconscionable. But these should be a contract analysis, not a jurisdiction analysis. So I think, yes, a vertically integrated global economy will give rise to a change in the approach to jurisdiction agreements, but I would suggest it's not a change that is met entirely by the proposals of the ILA Committee or the Draft Judgments Convention, the Special Commission of the Hague Conference, but rather that it is an approach that should take into account the possibility of refusing to give effect to a jurisdiction agreement, but on contract law principles. So that's all I'm trying to say on that. I could give one example, I guess, one current example, which kind of brings it to life, and that relates to the names litigation, the Lloyd's names case, which I would hope everybody has at least some passing familiarity. It's hard to avoid that case or litigation around that if you've been in the biz in the last 10 years or so. The commercial court in London has just delivered a judgment a couple of weeks ago, which effectively is in favor of Lloyd's and against the names. But that's not the point that I want to make. It's really that many months ago, when this litigation was just ramping up, some of the names started actions in Australia as well. And of course, this was in contravention of the jurisdiction agreement in the contract. So there was an anti-suit injunction issued out of London, and the analysis and that anti-suit injunction will now be revisited now that the litigation in London has been completed. But the question is whether the analysis of the influence of the jurisdiction clause on whether or not the Australian courts should assume jurisdiction, whether that will follow a forum non-conveniens or a non-contractual approach, or whether it will take into account the contract. Now, it's an interesting case because the names litigation itself is one that turns on questions about whether individuals should bear full responsibility for the contracts that they've entered into, or whether there are some sort of overriding circumstances which would excuse them of those responsibilities. So the analysis of the jurisdiction clause in contract law principles will tend to fold into the merits of the case, and I'm fully aware of that. But I would still suggest that the analysis of that jurisdiction agreement and whether it should be given effect to should follow on contract law principles. Anyway, enough said about that. I'll turn to the next traditional form of contest of jurisdiction, which I think will be shaped and influenced by the vertical integration of the global economy, and that is the possibility of parallel proceedings and the possibility of alternative forum. In the civil law, this concern is known as lees pendens, and they have a very simple approach to this, and that is that the court that is first seized of a case is the only court that can decide it. all other courts must cease and desist immediately. And it's a very mechanical and very effective approach, and it is found in Article 21 of the Brussels Convention. And in, I guess, colloquial terms, it drives the English lawyers nuts, because they say there's nothing principled about this result, and all it does is foster race to the courthouse, which is surely no way to conduct litigation. It doesn't it doesn't provide incentives to settlement or to restraining yourself from litigating. It provides an incentive to get into the courthouse first, because then you can choose the forum. That's the approach in the civil law. The civil law is quite content with that approach, though. The approach in the common law to parallel proceedings or the resolution of which is the appropriate forum is, of course, that based on the law of forum nonconvenience. If a court is thought to be clearly not the most appropriate court, then the defendant will object and ask the court to exercise its discretion to stay the matter in favor of the more appropriate forum. And so the resolution of these issues is conducted in a discretionary way and based on a principled analysis of which is the most appropriate forum. The problem with this, from the civilian law perspective, is there is considerable uncertainty, and it's a bit messy in their view. There is always the possibility that a court will not agree that it is not the most appropriate forum, and it will continue to exercise jurisdiction, and then a disgruntled defendant might commence a second action in the forum that is thought to be appropriate, and you will have parallel proceedings. Or in the alternative, the defendant will go to the forum that the defendant says is the most appropriate or the more appropriate forum and ask for an injunction, just as happened in the Lloyd's case, ask for an injunction to prevent the proceedings in the first forum from going forward. So it can be messy and awkward. Now, common lawyers are more comfortable with that because they think that this residual possibility is really, in fact, quite small, and it occurs fairly rarely. And the degree in any legal system to which the courts are concerned and to which the legal community is concerned about this possibility will be reflected in the care with which the courts take in analyzing these issues and in coming to their decision on them. So we find in Canada, our courts are really concerned, really troubled by the idea of parallel proceedings, and they are disturbed about the idea of a matter being decided in the less appropriate forum. So they do tend to exercise some circumspection in assuming jurisdiction where it may be a questionable case. They do tend to be very welcoming of requests for a stay on a discretionary basis, and very content to grant them where they think it is appropriate. So the problem is not so much how these methods operate within the civil law or the common law, but how they fit together, because when they work together, it's a complete disaster. If one person thinks that it is a civil law court that is the court of their choice, then of course the thing to do is not to act as you would in the common law and continue negotiations and exchange correspondence and that sort of thing. The thing to do is to rush out and get yourself filed in the civil law court, because then the civil law court, being the first seized, will never relinquish jurisdiction. And in many civil law courts, indeed, there is no law of forum nonconvenience. They have no capacity to exercise discretion to stay their proceedings. So the common law court will then be approached, and the person will say, I can't get any relief from the civil law court, and it is an inappropriate forum. So I would ask you to assume jurisdiction in any event. And so there we have the worst of all worlds. We have a common law court issuing an injunction to prevent an action from going forward in the civil law court, which has happened, or the common law court commencing and carrying on with the parallel proceedings. The civil law is offended by the notion of injunctions and parallel proceedings, and the common lawyers are offended by the notion that the civil law court has assumed jurisdiction and will not relinquish it on principled grounds. So the challenge that's been seen in places like the International Law Association Committee and the Hague Draft Judgments Convention negotiators is to find some way to put the two together. And they've proposed to do so, I think, in a delightfully neat and promising way of actually just combining the two and saying that this will replicate the strengths of both. They've said that the court first seized should be the only court that can decide whether it has jurisdiction or whether it should not exercise jurisdiction, but that court must do so on forum nonconvenience principles. So if it happens to be a civil law court that's first seized, it will be required to review its assumption of jurisdiction in the way that a common law court would. But the civil law, the civilian lawyers are given a certain comfort level because then they are reassured that this decision won't be made in various fora and in different ways. It will be made only in the court first seized. So there's a certain sort of neatness and tidiness that suits them. This is a wonderful idea, but once again, I would suggest that it is a 21st century solution for a 20th century problem, in the sense that I would argue we have only backed up the concern if there is an access to justice concern that is a component of the decision in forum. We've only backed that concern up to the determination of jurisdiction. It bears a little bit of explaining. If the reason why the court that is chosen by the plaintiff is an inappropriate forum, if the reason for that is that the defendant cannot practically get there and defend, then how is it that the defendant can practically get there and challenge jurisdiction? So at least in the eyes of individuals and small businesses who are sued in distant fora, in distant courts, who regard those courts or have a reasonable argument that those courts are inappropriate fora, in those cases, they will see that the proposal that is made by the ILA committee and the draft judgments convention folks to be equally as denying of access to justice to them, because they can't get to that distant court to argue that it should not assume jurisdiction. So the problem is only then replicated at the jurisdictional determination level. I don't put this out because I suggest that there's an easy answer. I don't put it out because I would like to suggest that if we spent 10 minutes together here, we could do a better job than all those better minds put together for several years. But I would suggest that the problem needs to be addressed and needs to be dealt with. In part, one of the solutions to this could be that we established some method of transferring proceedings, something that operated in a less cumbersome fashion, a less expensive fashion, and more efficiently, such as exists now between the federal courts in the United States, or as exists between the state courts in Australia with their cross-vesting legislation. And all the references to those are in the paper, and in many cases the website, so you can sort of check out the legislation or the latest on each of them. We have such a proposal now in the books from the Uniform Law Conference, and we've had such a proposal for a number of years. It's never been picked up. It's in our Court Jurisdiction and Proceedings Transfer Act, which hasn't in fact been put into force in any of the provinces yet. But Part 3 of that provides for transfers of proceedings between provinces. And our act actually goes further than the other two models, the American and the Australian model, in that it proposes that a part of a proceeding could be transferred. So, for example, if the evidence and the witnesses on liability were somewhere else, in theory, you could send off the proceeding for determination of liability to the other jurisdiction and then have it returned to the court for determination of damages, for example. Also, our legislation proposes that these transfers not be limited to interprovincial transfers, but also extend to international transfers. I'm not entirely sure how that would work, but it sounds like a good idea or a good starting point. Now, some of this, I must stress, will tend to resolve itself as courts become more familiar with dealing with contests between jurisdictions. There will be a greater comfort level among individuals and small businesses that the matter could be resolved in a distant forum without them. But at the moment, while things are largely up for grabs and things are relatively uncertain, you can well understand that people want to be sort of right there, arguing their case, seeing how it's decided, seeing what issues are put and how they're addressed. So there remains, as I would suggest, a considerable concern about access to justice in the existing proposals. Now, just so that we do have some time for questions left. I just want to raise a sort of a number, a grab bag of other things that are, other developments that are changing the contests between jurisdictions. And the first is the harmonization efforts that are being made. If a contest between jurisdiction is now being waged because there is a difference in the substantive law, then that will end when we're talking about things like sale of goods to a certain extent, because we will have the Vienna Sales Convention that harmonizes the substantive law that applies to sales of goods across international borders. Now, if anyone hasn't looked at that is one particular piece of legislation, the International Sale of Goods Act, that everyone should have a look at as a matter of professional responsibility, because it's the kind of set of principles that applies unless the parties opt out. So there are a remarkable number of cases in which the International Sale of Goods Act should determine the rights and obligations between the parties where the parties just don't know that that is the case. And so when I was discussing this with an LLM class a couple of years ago, someone ventured the obvious question, well, what if we are actually in a proceeding, in litigation, and we suddenly become aware of the fact that the rules of the Vienna Sales Convention should apply to determine a particular issue, and it has not been raised by the other side? Well, I would expect that you would all know the answer to that. You have an obligation to alert the court to the appropriate law, and yet there are many, many decisions reported now which inappropriately fail to make any reference to the Vienna Sales Convention. So have a look at that. Another very interesting project that was mentioned by James Morton is the American Law Institute's project for the transnational rules of civil procedure. The theory behind that is that if we all operate, or at least if many places operate on the basis of the same rules of procedure, you know, I mean, I'm talking about very basic things. How many members of the panel should there be in a court? What are the rules of evidence going to be? What is the basis on which the court can levy fines or for failure to pay a judgment? All of these very sort of nuts and bolts things, if they are in fact harmonized, then they will be one residual basis for contest of jurisdiction that will evaporate. Because apart from such a harmonization effort, it is a standard rule that all courts, and you can see why immediately, all courts apply their own rules of procedure regardless of which law they apply to the substantive law issues in the case. So even if a court is hearing a case about a contract that is governed by the law of France, if the Ontario court applies the law of France, it certainly doesn't vary its procedural approach to the case. It still applies the law of Ontario to procedure. You still have, 60 days to respond to the notice of proceeding. You still have to submit a statement of defense, et cetera, et cetera. So this would provide a uniform or harmonized set of rules of civil procedure that would apply in various courts throughout the world for these kinds of international civil and commercial actions. Now, I mean, it may be a long way off, but it's, once again, something to keep an eye out for. Another kind of development that is affecting contests between jurisdiction, of course, is e-commerce. And I mention it because it's different from the harmonization efforts that will eliminate contests between jurisdiction. It's different in the sense that it might create, or it is likely to create, a whole new area of law in which traditional jurisdictional boundaries make no sense in any event. I'm not talking about contracts that are communicated, or even contracts that are entered into in the digital environment and performed in the real world, because those contracts can be analogized to other contracts that are communicated in various forms. The law has adjusted beyond sort of verbal and written agreements to deal with agreements that are concluded over the telephone, the telex, the fax, and it will certainly adjust to deal with contracts that are concluded over the net. But there are many contracts now that are, in fact, also performed in the digital environment. And to suggest that they have a meaningful, even if it's notional, tie to a particular jurisdiction, one as opposed to another, it's difficult to see any sense in that. So it is entirely likely that we will have either emerge or developed, hopefully developed, a set of principles that will be uniform throughout, if only because there's a certain coherence and cohesiveness to the digital environment that is rather more compelling from a logical standpoint than trying to parcel it out to where servers are, for example, or where you sign on to the net. There are a couple of projects underway on that front. One is under the auspices of the Hague Judgments Convention, and the recent report on that can be found on their website, and also the project sponsored by the American Bar Association, which has a very extensive report, which can also be found and downloaded, and the site is included there. The last point that I want to make about contests between jurisdiction, and I know it's been sort of a lot that I've been covering now, is that the nature of civil litigation, as it changes through the vertical integration of the global economy, it too will in fact change the nature of contests between jurisdiction. And I'll give just a couple of examples of that. One of them, class proceedings, has created in the minds of many its own access to justice considerations that tend to be factored into deciding or resolving a contest between jurisdictions. So, for example, if the only way to get a claim up and running is to have it subsumed within a class action, and if there is a class action available in one place and not in another, courts will tend to say that that alone might suffice to to make that court an appropriate forum. And there are a couple of examples of this. One of them is in the Lubb decision by the House of Lords, L-U-B-B-E, by the House of Lords in July of this year, in which there was a claim for asbestos exposure in mines in South Africa made in London. And the court specifically acknowledged in that determination that the plaintiffs in that case, there were about 3,000 of them, would be able to get their action up and running if they were to have the benefit of the grouped proceedings in the English courts, but they would be unlikely to be able to pursue their action in South Africa. And it would in fact be a denial of justice under the European Court of Human Rights, the European Convention of Human Rights, to stay the action in England in favor of South Africa. It was just sort of a let them eat cake suggestion they suggested on the part of the defendants. We had a similar result in class action about diet pills and the health hazards that they cause, and that decision was released by Mr. Justice Cumming in September. The suggestion by the defendants was that the plaintiffs should be required to sue if they were able in France, and of course there are no class proceedings in France. And this was only, of course, part of the basis for the result in that case, but it was a factor that was taken into consideration. Now that's the access to justice point on class proceedings that is affecting contests between jurisdiction. But there is also another interesting sort of set of issues that arises around the possibility that if there are class proceedings available in more than one jurisdiction, would it in fact be the substantive law that then decides whether or not the matter should be pursued in one place rather than another? So the example that I've given in the paper is the one of the YBM Magnix litigation, a securities fraud action. Actions have been commenced in Ontario, and I think they have not yet been certified. Actions were also commenced in Pennsylvania. And in Pennsylvania, the provisions of the Securities Act allows for deemed reliance, which in secondary trades, a fraud on the market theory for people who are familiar with the Brecht litigation, it's not available in Ontario. And so the suggestion is that the Pennsylvania action is in fact an action that is more helpful to plaintiffs than the Ontario action might be, and so it might be appropriate for Ontario courts to recognize that plaintiffs in Ontario should be in fact subsumed under a class proceeding that is commenced in Pennsylvania. Well, there are sort of interesting spin-offs to this, and not the least of which are actions that are being, I think, possibly have already been commenced against the Ontario Securities Commission based on why was it not dealt with here in Ontario. These are where the stocks were traded. And also the suggestion by defendants that they should be judged by Ontario standards of liability and should have be able to defend on the basis of Ontario procedural rules. Read for that no deemed reliance and no fraud on the market theory, because the trades were actually made in Ontario. So that's an interesting set of concerns that suggest that the substantive law might once again come into play where there are class proceedings in both places, and might itself become a basis for resolving contests of jurisdiction. So it's just sort of yet another twist in this very interesting series of cases. And the last point that I wanted to make on the way civil litigation is changing the face of contests of jurisdiction are the public interest litigation actions that are being now commenced by governments on behalf of collectives. And an obvious example of that is the tobacco litigation. So for those of us who missed it, the Attorney General of Canada commenced an action some months ago in New York against the tobacco major players in the tobacco industry, shall we say, for smuggling cigarettes across the border through the First Nations reserves in violation, in order to avoid our increased tax that we had in 1990, 1991, about that time frame. Well, it's certainly changing the nature of contests between jurisdictions in the sense that this was an action commenced under RICO legislation, under the civil liability aspects of the RICO legislation in New York, certainly legislation that is not available to assist in litigation in Canada, and yet this was a claim being brought by the Canadian government. So at one time, there would have been no contest between these jurisdictions, because it simply would never have been considered possible for, never considered appropriate for a court to entertain an action by a foreign government for recovery of its taxes. And the American jurisprudence has a similar doctrine called the revenue law. For us, it's the foreign public law exception. For them, it's the revenue law. And that was still a basis for considering the action to be barred in the United States. But my understanding is that that one is not yet over, and that there is an appeal underfoot. And in fact, Canada was recognized by the court at first instance to be a person under the RICO legislation. In other words, potentially having standing, but nevertheless whose claim was barred by this traditional rule. And so that's being now appealed. That will certainly change the face of contests between jurisdictions when we not only have collectives bringing actions, but governments on behalf of collectives bringing actions in foreign courts. I know that's quite a bit, and we are sort of now rapidly progressing towards the stratosphere, so I think it's probably best to stop. I should mention the last point. I don't have a conclusion, if you've noted in my paper, and that's very simply because I couldn't see how that there could be a conclusion. This is surely only the beginning.
Yes, we do have time for a couple of questions, if there were any. So.
Yes, I was wondering, a lot of what you're saying in terms of the convention seems to be predicated on the notion that a signatory state is going to be able to enforce the convention within its own judicial system. How can that work in a nation that's not a unitary system, such as Canada or the United States? You've seen the UN recently tell the Ontario government and the Canadian government that we're discriminating by giving funding to Catholic schools and not to others. And the Canadian government says our hands are tied by Section 91. And when we have the non-obstante clause, how do we do anything to make any of this effective?
You're absolutely right that the federal-state issues are very significant, particularly for Canada. There's no question about that, and that's still being debated. I mean, the convention has quite a ways to go, but what I should suggest is that the jurisdictional rules across Canada tend to be largely harmonized, especially as a result of the recent interventions by the Supreme Court of Canada. So there would tend to be a collective understanding of what our objections might be to any particular provision in the convention. So that can be of tremendous assistance. But also I should suggest that our delegation at The Hague is in regular contact and has done its best to be highly consultative with persons across Canada, experts across Canada, to help to assist or facilitate the ultimate implementation of the convention. But you're absolutely right. Federal state is a major issue. I mean, we deal with that on almost every multilateral effort. Because, well, certainly every multilateral effort that affects a private law matter, because as soon as we get into 92, Section 92, we have that concern about being able to implement or live up to our obligations. Yes.
I'm wondering, when we were discussing the role of formal means analysis versus an analysis adopted in the civil law system, I've had some experience trying to deal with the common law jurisdiction taking jurisdiction over a matter on the basis of a law or jurisdiction statute, and then undertaking an analysis which isn't fully on the basis of formal convenience. It doesn't explore all of the branches of that test. It looks into some of the factors. And I'm wondering how you see the interplay between our courts trying to decide whether to take jurisdiction over a parallel proceeding when another court has confirmed jurisdiction on the basis of law or statute.
I would suggest we stay tuned. We actually have that going up to the Supreme Court. I always sort of like to send up a flag when they grant leave on a matter that relates to conflict of laws, because it is relatively rare. But we have the Westek case, which is going up to the Supreme Court. The last I heard was that there had been some request for extended time on filing of factums, but we are moving along on that. In that case, there are actually two cases in out of British Columbia. The Thrifty case, I think it's 427900. It's a numbered company against Thrifty, in which there were parallel proceedings in Ontario and in British Columbia. And they finally sort of broke tradition with the old Avenue Properties rule that parallel proceedings aren't really a problem, and said that they are a problem and we have to respond accordingly. Following that, there was a parallel set of proceedings in British Columbia and in the United States. And that is the decision that's going up to the Supreme Court of Canada. And in that case, the first seized court was the American court. The parties that would have preferred British Columbia forum objected strenuously and made a series of arguments. I can't say how the issues will be precisely framed, but yes, it's a hot issue, and yeah, watch your Supreme Court of Canada bulletins.
Well, I want to thank Professor Waechter again for her talk. It seems that we've come a long way from juridical advantage, which is kind of where I left things. But thank you very much, Professor Waechter. I think we all appreciate that. Our next speaker is Pat Flaherty, and Mr. Flaherty will be speaking to us on admissions, requests to admit, and reading in unpolished gems. I had the privilege of working with Mr. Flaherty some years ago, and he stayed at a respectable law firm, and I didn't. He has appeared before all levels of court, federal and provincial, in Canada. He teaches and has taught at a number of Canadian law schools, and he is the co-author of the forthcoming book with the very intimidating title, Understanding the Personal Information Protection and Electronic Documents Act. So with that, I'll turn the floor over to Mr. Flaherty. Thank you, Pat.
Thanks, James. I'm just delighted to be here, although I'm not sure if I should thank or hit James Morton for having to speak about requests to admit. I have to say, trying to make that topic interesting is sort of like making shag carpet seem appealing as a design choice. But in any case, I really have, I think, two main points to make, and these are brought out in the paper. The rules regarding admissions, requests to admit, and reading in from discovery are, in my view, completely underutilized by most people in Ontario, based on some anecdotal evidence that I'll get to. And secondly, that the rules as they're framed and as they've been interpreted actually provide some potent weapons that you can use in civil litigation, provided you give a little bit of tactical foresight to how you're going to use these rules. So having said that, in terms of my remarks, I'll deal first with requests to admit, discussing a little bit about the mechanics of Rule 51, dealing with a few legal points that emanate from the case law to the extent that there is any in this area, and then a discussion of what I call practice points, or some points you might want to keep in mind the next time you're sitting down to either draft or respond to a request to admit, and how to use admissions obtained at trial, and basically the same format with respect to reading in admissions from discovery. With respect to requests to admit, Rule 51 is the governing rule, and there was a notice to admit procedure that was included in the old rules, I guess as they're called, which was largely similar to what is in the current rules, except that there were no cost consequences that were ever imposed with respect to the notice to admit procedure. And therefore, if you ask anyone, and when I was sitting down to do this, I spoke to Charles Dubbin about how often or not he would deliver a notice to admit when he was practicing in the 50s and 60s. He said it was most infrequently, and people just would ignore them when you got them, as there was no requirement to respond in any timely way. But under the new rules, you're entitled to serve a request at any time, although, as I'll get to, that's been tempered by some jurisprudence. You're entitled to request, in effect, two things: the truth of facts and the authenticity of documents. The response is due within 20 days, unless you can get an extension, either by agreement or by order. And in responding, you're really entitled to do three things. You can admit the facts and the authenticity of documents, deny the facts or deny the authenticity of documents, or refuse to admit or deny, provided you provide some form of explanation. And under the rule, there are provisions where deemed admissions will pertain. First, if you don't answer the request within 20 days, you're deemed to admit everything in it, subject to getting those deemed admissions withdrawn by a motion. Secondly, you're deemed to admit if you don't specifically deny or refuse to admit or deny with an explanation any particular fact that's been sought to be admitted. And finally, you're deemed to admit if your explanation or your refusal to admit or deny isn't accompanied by an explanation. And finally, there are cost consequences which a court can take regard to when making cost awards after trial, where a party has admitted or denied facts. So that's the rule. In terms of when you can serve a request to admit, well, the rule says at any time. It's been interpreted, at least in a few cases, as not being an absolute entitlement. In the Enfield and Blair case, for example, that's referred to, I think, at page 7 of the paper, the plaintiff, I think, in that case had served a request to admit right at the outset of the case while there was a pleadings motion pending in which one of the defendants was seeking, in effect, to get the action struck out as against them. In that case, and that motion wasn't going to be heard before the 20-day time period would expire. In that case, Mr. Justice Farley in the commercial list said in the circumstances, the defendants who were moving to strike need not respond as it was a premature request. So notwithstanding the any time language in the rule, there are obviously going to be situations in which you can make a compelling argument that you ought not be required to respond to a request. Also, and this is referred to in the paper, that the rule seems to have unique application in class proceedings. In the Panasonic case, the plaintiff, along with their statement of claim in a class proceeding, served a very detailed and long request to admit that essentially asked all of the proposed class defendants to admit all of the material facts in the claim. And in that case, the proposed class defendants, in effect, got a stay of having to respond if and when and only when the action was certified as a class proceeding, again on the basis that the request was premature. So if you're on the receiving end of a request and you think it's for some reason premature or inappropriate insofar as having to answer at an early stage, then these particular cases might have some support for your position to at least defer your response, although obviously not defer it indefinitely. In terms of what is an improper and conversely proper request to include, this obviously is important for a number of reasons, not the least of which is there's a decision of Master Pepiot called RSC Management, which is referred to at page 4 of the paper, where he suggests if you serve a request that includes improper matters in it, a trial judge should and could have regard to that in awarding costs against the party who served the request. So you shouldn't just use the request in addition for other reasons to throw anything in it, because it might visit negative cost consequences on you. The problem, though, is the law in Ontario isn't particularly clear as to what is a proper or improper request at this stage. And this isn't mentioned in the paper, but there's a huge body of case law in the U.S., as there is on everything, on this particular issue, which, depending on your circumstance, might be helpful in arguing some point. But in terms of things that might be improper, what about irrelevant matters, things that have no bearing on the issues in the litigation as framed in the pleadings? Master Pepiot, again, in the RSC Management case, suggested you ought not include irrelevant matters. There doesn't appear to be any additional Canadian case which considers that issue directly. As to privilege, are you entitled to demand what ostensibly would be matters which would be covered by some privilege, settlement privilege, solicitor-client privilege? Again, no specific case law in Ontario on this point, but presumably the normal rule or application of privilege should apply in any context. You shouldn't be forced to disclose otherwise privileged information or material simply because it's included in a request to admit. However, I think you have to have regard to the fact that facts themselves aren't necessarily privileged, although the form in which they were communicated might be. As to legal matters, are you entitled to demand, in effect, someone admit a legal proposition? Up until, I think, last year, the short answer would have been no. A request to admit specifically says you're entitled to seek admissions of facts. Legal propositions don't fall within the definition, although there was a case of Mr. Justice Nordheimer called Foundation for Equal Families, which is at page 5, or referred to at page 5 of the paper. That was a case in which the Attorney General, who was respondent in an application, was asked to admit that 58 pieces of federal legislation violated Section 15 of the Charter. The Attorney General refused to admit, asserting that what was sought was propositions of law, not fact. The applicant moved for an order requiring the AG to answer, and Mr. Justice Nordheimer, much to some surprise, I think, ruled that, and these are his words, as long as one element of the admission sought is factual in nature, a liberal interpretation of the rules should permit that matter to be the subject of a request to admit. So in that case, to the extent that the question of whether legislation violated Section 15 imported some kind of factual element in addition to a legal element, which it clearly did, the Attorney General was required. Now, leave was sought and granted, and this is referred to at page 5 of the paper as well. The motions judge on the leave application doubted the correctness of the motions judge's order, but unfortunately for anyone who was hanging on the outcome of this case, at least insofar as the request to admit component of it was concerned, the matter became moot, and the appeal was stayed. So there is, if you're inclined to draft your next request to admit seeking propositions of law, you could at least hang your hat on Mr. Justice Nordheimer's motions decision as some basis for it. There is some law, not in Ontario, about the impropriety of demanding, in effect, the party admit your entire case. And this is referred to at page 6 of the paper, coming out of Saskatchewan. And comments were made in that case that you can't, in a request to admit, demand your entire case. That's a bit of an unusual situation where the plaintiff essentially just asked the defendant to admit at the beginning of trial, under their rule, that all of the facts included in their trial brief, which included essentially like an opening submission and factum type of deal, everything in it was true. So the form of it was obviously problematic. But at least my view, and I think if you read the rule, there's nothing precluding you, if you're so inclined, to sit down and list all of the possible material facts you need to prove your case and put them in a request to admit. It'll be long. You're not likely to get admissions of all of those things, but if you want to spend the time and you think you're going to get some advantageous positioning as to costs by virtue of that, then by all means, I don't think there's any legal prohibition on you doing it. When can you challenge the propriety of a request to admit? Again, the law isn't entirely clear in Ontario. There are some circumstances, I think, based on some of the case law, where you can make a compelling argument that you don't have to answer because of the content of the request as opposed to, say, the timing of it. Again, in Mr. Justice Nordheimer's Equal Families case, he challenged the conventional wisdom that it's really for the trial judge to decide whether a request contains proper or improper requests as to fact. And what he said in that case, he distinguished between a challenge to the operation of the rule and objections raised as to the applicability or scope of the rule, with the latter being something that a motions judge could consider. Now, I think you could probably fit anything in to the definition of operation of the rule or correspondingly scope of the rule. So there is at least some comment in this case that might support a motion to strike out a request to admit when it's delivered as being in some way improper. In terms of responses, again, this is sort of my mantra, and maybe James Morton's going to give me the hook, because there is uncertainty in the law in this area as well. It seems clear that you can't refuse to admit or deny facts on the basis that they are inadmissible at trial, because that will ultimately be a determination for the trial judge. But as to irrelevant facts, if faced with a long and perhaps abusive request to admit, what are you entitled to do? Certainly, it's my view that you can move under Rule 2511 to have it struck out if it's abusive. And in the appropriate case, I think a judge will grant that relief. There's some law, again, coming out of Saskatchewan on that point, which is referred to in the paper at page 9, which might be helpful if anyone is faced with that situation. What about a long, prolix, or abusive, or otherwise abusive, just by virtue of its length request? The rule doesn't impose any limitation on the parties as to how long your request can be, and there's at least one case where someone served a request that, with documents, was over 1,000 pages long. And one can imagine the joy of having to pick through that. But in that case, it was held to be not improper to serve something that long. There is some recent law that suggests you can actually deny facts which you know to be true, and there's nothing inappropriate or improper about that. Obviously, that's got to be accompanied with a caution, and I'll get to this in terms of the practical points, but I think trial judges are hyper-conscious of people taking unreasonable positions at trial, including denying facts which ought not be denied or taking unreasonable positions. And I'll give you an example later at a trial I recently did where this happened. So even though you might be entitled as a matter of law to deny facts which you know to be true, that's I think a decision you have to take extremely carefully and with a high degree of caution, lest it make you appear entirely unreasonable before the trial judge. With respect to the cost consequences, and this is referred to in the paper, if you do a quick law search since the rule was put in place in 1985, you actually only find 10 cases in which the cost consequences for refusing to admit facts are actually relied on by a trial judge in terms of awarding costs. And, well, based on a straw poll I did, requests to admit aren't all that common. Being used only in about a third of the cases that go to trial. It seems that there have to have been more than 10 instances where requests to admit were served by plaintiffs who were successful, all of which is to suggest that trial judges, for whatever reason, aren't relying on the cost consequences under the request to admit rule to impose particularly solicitor-client costs. Which sort of begs the question why you ought to serve a request to admit at all, or if you're receiving one, why you should ever admit anything and just not deny as a matter of course if the courts aren't going to resort to the cost consequences. So that's obviously something to have in mind. As I say, you either sit down to write or respond to one of these things. There is a way in which you can use a request to admit to potentially get a distributive cost award. That is a cost award that, rather than awarding costs on the basis of complete success or failure, as is often done now, on really on an issue-by-issue basis. And the Court of Appeal in Ontario has explicitly rejected the concept of distributive cost awards recently, although there was some earlier authority that's referred to in the paper that suggests it was available. But that was just as a general matter of judicial discretion. You can, I think, by framing your request on really on an issue-by-issue basis, get a distributive cost award if you have a trial judge who actually is going to give effect to the cost consequences of the rule. But I think if you can demonstrate at the end of the case, even though you haven't had complete success, you delivered your requests, denials of all the material facts to support a particular issue were made, and you've proved all those facts to be the case, you at least have a basis on which to position an argument for distributive costs outside of some normal judicial discretion, but rather focusing it right on the rule. So that I think is somewhat significant and could be helpful in an appropriate case. In terms of practice points, these are all set out starting at page 14 of the paper. But as you sit down to compose your request, you should obviously make sure you're complying with the formal requirements of Rule 51, and to the extent that you can discern anything from the case law that I've referred to, draft your request in accordance with that case law. That doesn't mean you should be overly circumspect about what you include in your request. I think, at least in my own experience and others that I work with, were somewhat surprised at what people will often admit, particularly early on in a case when they may not appreciate the full significance of it. So don't hold back simply for the purpose of being technically compliant with the rule or the fear of having your request struck out. On a substantive level, I think before you deliver your request, make sure the legal theory of your case is clear in your own mind. It should be, obviously, when you draft your pleading, but since the rules don't specifically refer to this, but I think if you can rely on a request the other party has served at trial, to the extent that they're now trying to deviate at trial from an earlier position set out in a request, I think you're fully entitled, although the rule doesn't say it, and it's a matter of judicial discretion. I think you can rely on it as being representative of an opposing party's position, all of which is to say, be careful when you're about to draft and serve one of these things. You should think of whether there are some facts that are going to be more compelling at trial if they're proved through a witness rather than through a request. Because I think there's a good argument that to the extent that you have sought and obtained an admission, that a trial judge need not and should not necessarily hear evidence which is simply duplicative of the admission that's already been obtained. So be careful about about important and key facts that'll be very compellingly and perhaps sympathetically presented through a witness that you know are going to be admitted in a request, because you don't want to undercut the storytelling that goes on at a trial, and that might be important depending on the type of case you're dealing with. Depending on when you're going to deliver your request, be careful about how much detail you include in it. And as I say in the paper, there are times when, if you're going to serve an early request, you're ill-advised to include too much detail in it, in that you effectively could tip your hand to your opponent in a way that educates them just too much as to where you're going with a case. And I think there's a way you might be able to accommodate this. The rule contemplates, and there's law that says you can deliver more than one request. So early in the case, if you think you're going to capture these cost consequences, which are supposed to pertain under the rule, consider drafting a more limited request and follow up after discovery, after you've pinned down the other side with a more detailed request. When you're going to be calling expert evidence, you can use a request quite effectively to put in the facts on which the opinion is based, particularly if you don't have live witnesses who are necessarily going to do it. So you should, I think as a matter of course, if you're going to call expert evidence, always consider a request for that purpose. In terms of documents, in addition to seeking the authenticity of documents, you can use the request to get admissions of the facts necessary to fit documents in as business records. And I know I did this with Charles Scott a few years ago in a case where we had a bunch of third-party documents in effect that were business records. The other side indicated probably that they were going to object rather than going into evidence as business records. And the document maker was in Australia, and it wasn't particularly feasible to have us bring them over, and they weren't particularly available. So we served a detailed request which included all the material facts we needed to establish that these documents were business records. And lo and behold, the other party admitted those for whatever reason, and we were able to get them in at trial, notwithstanding the other side's objection on the basis that they were business records based on admissions gain. So that's something you can use the request for, I think, in a fairly helpful way in the appropriate case. Just a drafting point, you've got to set out your facts in individual paragraphs, one fact per paragraph, because you want to avoid any refusal to admit or deny with an explanation that they don't understand what you're asking be admitted. And also try and keep your adjectives to a minimum in a request, because the extent that you're trying to characterize facts, you're going to get refusals or denials, and you perhaps might not be able to prove a matter of characterization at trial and get whatever cost consequences you might. In terms of the use of admissions obtained at trial, the rules don't specify exactly how you use these things. Certainly it's been my practice, and I've seen it done by others, is to file a book of formal admissions at the outset, during or before your opening. There is, I think, and I addressed this in the paper, a way to make better use of your admissions at trial, which is to consider filing really a more expansive brief that has all of your admissions in it, formal admissions from the pleadings, from requests to admit, and from discovery, and organize them in a way that really marshals those admissions to your best advantage in the case. And either that's by some form of chronological way, depending on the case, or on an issue-by-issue basis. And I think, at least it's been my experience, that trial judges find this helpful if they can get these things in context at a fairly early stage of the case without giving the trial judge too much detail, but enough so they know what has been admitted in the case. So consider doing that rather than just handing up your formal admissions or just referring to them in your argument at the end of the case. In terms of when you're the responding party, if you're faced with someone filing this book of admissions and they haven't previously either disclosed it to you or asked you to take a look at it, I think it's perfectly appropriate to ask the trial judge a reserve on having the thing marked as an exhibit or being put into evidence, simply to give you an opportunity to review it, to see that it's accurate to the extent, as I'll get to, it includes discovery excerpts, that they're fair and full and whatnot. And the other thing, as a responding party to a request to admit, to remember is that it will usually prod in yourself just by, I don't know, maybe it's sort of lemming-like mass scientific behavior, etc., that you're going to probably want to respond with your own request when you get served with one. And so don't resist the urge to model to some extent that it's proper your opponent's request, simply because it'll make it more difficult for them to object to yours if you're modeling what they've done. So that's requests to admit. I know you're all excited, but reading in admissions, and this is addressed really starting at page 19 of the paper. The mechanics of the rule are set out in Rule 3111. And the purpose of the read-in from discovery actually determines the requirements you have to meet to read it in. And with respect to admissions from discovery, you're entitled to read them in at any time as part of your case, and that includes defendants, which wasn't previously provided for in the old rules. And with respect to admissions, you don't have to have put them in cross-examination to the opposing party, which is an important distinction. If you're reading in to impeach credibility, the rules in the Evidence Act require that you actually put it to the witness who you are impeaching. But if something is an admission against interest, you don't have to put it to the other party, nor would you ever want to, simply because you're just going to give them an opportunity to qualify it. So that's an important, I think, distinction in the rules. In terms of case law about reading in, there isn't a whole lot of it, simply because it arises in the midst of trial, and a lot of these things don't get often reported. But the most important thing about reading in is that you are required to be fair, both under the rules and under trial practice. And there's a case referred to at page 22 of the paper called Capital Trust and Fowler, which sets out the requirement to be fair, which is that you have to read what is necessary to understand and appreciate the extent of the admission. And this is actually codified in the rules in Rule 3111 sub 3. So the important point from the perspective of the one who is doing the reading in is you have to be extremely cautious about complying with the fairness requirement for two reasons. First, a substantive reason. You're going to be required to read in as part of your case unhelpful evidence that you're trying to parse up or cut out or edit out in the portion of the transcript that you're reading in. And that unhelpful evidence will become part of your case, so you obviously want to avoid that. Secondly, in front of a trial judge, and I think everyone who practices litigation has seen this, if someone is unfairly editing a transcript, the minute that is brought to the attention of the trial judge, you can hear the great sucking sound in the courtroom, and the counsel just loses all credibility, and the trial judge can't trust anything that they say or do from that point on. So it's you got to be extremely cautious, I guess, in choosing your read-ins to make sure you're not going to get whipsawed into reading unhelpful evidence as part of your case. Notwithstanding that, under the rules, you actually do have a right to rebut unhelpful evidence that you've read in, unlike a judicial admission pursuant to a request to admit. You're actually entitled to qualify and rebut evidence that you've read in as part of your case. Having said that, though, and that's under Rule 31.11 sub 4, but having said that, if you've read in unhelpful evidence, I'm not I don't care if you have the right to rebut, the damage is sort of done all of again, which is to reinforce the point that be very careful as to what you're going to read in. In terms of practice points, at the front end, to obtain, I think, useful admissions on discovery, you obviously have to organize and conduct your examination in a way that is going to maximize your opportunity to get these admissions, and there obviously are a million different ways to do this, but if you're going to cross-examine during your discovery, follow the 10 commandments of cross-examination. Do it early on. Avoid all the pleasantries and the review of the resume, and get right to the substance right off the bat, and you'll often find that a witness will be either unprepared to deal with that or surprised, as will opposing counsel, and in the first hour of discovery you can actually get some good stuff and then go back and do your resume on the last day or whatever. Use summing up questions in discovery where fairly encapsulate maybe pages of transcript with a nice clean question that you can then read in without necessarily having to read in, as a matter of fairness, the whole previous 3 or 4 pages. Make sure also on discovery you get admissions with respect to documents so you can file them at trial. In terms of when to read in, if the trial judge's attention is most peaked at the opening of the trial, I don't think it's probably a particularly advised practice to spend the first 3 or 4 hours reading in from discovery, unless you've conducted a phenomenal discovery that's going to be completely dispositive of the case. You probably would use that time better with an important live witness. The modern practice seems to be, rather than actually reading, is to file your read-ins in the form of brief that I referred to earlier, and perhaps do some selective reading in, rather than boring the trial judge by line reading of pages and pages of transcript. But obviously you have to canvass the trial judge as to what his or her preference is in that respect. In terms of there isn't a requirement to exchange read-ins in advance of trial, but at a pretrial you should probably seek that as a pretrial order, so you have an opportunity, at least, particularly when you're the defendant, to be able to contextualize and require the plaintiff to read in appropriate parts of the transcript that aren't included, and also it'll give you some sense in many cases where you're going to want to prepare your own client for cross-examination. So seek that at a pretrial. Finally, at trial, when you're acting, at least for a defendant, to the extent that someone is trying to read in something as an admission that actually impeaches credibility, if it hasn't been put to a witness in cross-examination, you can object to its admissibility. So don't forget that right. Anyway, that is about all I have to say on these scintillating topics, and I'm certainly happy to take any questions if anyone can wake up.
I want to thank Mr. Flaherty, and I must confess, I thought that was quite interesting and certainly a very helpful paper. A very helpful paper on a topic that is not used as much as it could be. We now have a coffee break for a few minutes, and when we come back, Julian Porter QC will be speaking to us. So why don't we take a brief break at this point, and we'll see you back in, I think, 10 minutes. Super. Thank you.